If you've ever wanted to avoid using a real estate attorney, this is one episode you're not going to want to miss. Welcome, Don Lanson, my good friend and a prominent real estate business attorney here locally. There's a lot of lawsuits going on, right? Litigious lawsuits about real estate in general. So what are one or two of the things that are keeping you busy in today's world with real estate, and what should buyers and sellers be aware of?
So the number one thing I'm getting is disclosure problems. Buyers not doing inspections or testing of things that actually are maybe identified or briefly referenced in documents. I'll give you one specifically. Had a case the other day where somebody was buying a property, very expensive property, and the sellers indicated that they had radon in the mountains. Actually, they had radon that was tested as part of the process. Buyer took that information and thought it said carbon monoxide.
Oh my
Didn't
gosh.
get any testing done. 2 days before closing, found out, oh, I made a mistake in that understanding and never had it tested, and ultimately then tried to back out of the deal. Now we're in a deposit dispute. People always ask me, they'll come up and say, hey, I've got a deal here, and should I disclose X, Y, and Z? Of course, my answer is, if you're asking me, the answer is yes.
Yeah.
Because if it's important enough for you to ask me, it's probably important enough for a buyer to know.
So what is their statute of limitations for disclosing?
So technically speaking, it's 4 years from the date of the breach, which is usually when escrow closes. But there is sometimes an indication or ability to delay that for a claim of fraud, which is 3 years from the date the buyer knew or should have known of the issue. By the way, in case your viewers don't know, when you get an inspection report, that doesn't cover separate structures. It doesn't cover the roof. It doesn't cover the solar panel. It doesn't cover pools. It doesn't cover all of that stuff. And don't waive that stuff, because that's important, and that's probably the stuff you need tested sometimes more than inside the house.
And it's the most expensive, right?
Oh yes, big time.
Is there statute of limitation for a seller if something happened 15 years ago? Do they need to disclose that?
So there's a great question. So ultimately, again, the key is test is a very broad of anything that a buyer would think is material for their understanding. So the answer is yes. So even if you fix the sprinkler system 15 years ago and haven't had a problem, again, from a lawyer standpoint, you're going to have to put it down. I've had, and again, you as well, situations where I'll have people come to me, a seller with the disclosure, saying, I am so worried and frightened about what I have to put down and what I don't have to put down, and I have to do the whole fire, disclosure and stuff like that. Again, be as descriptive as you can. It's better to get everything up front.
So we, as agents, always say sellers disclose and buyers inspect. So what if you are a seller and you just forgot?
Oftentimes it may be a situation where you don't have actual knowledge. You may not have lived at the property. It may be a trust or a probate. You still have an obligation to disclose things you know, but you may not know of them. If you have been in the property and you just forgot, that's going to be an issue as to kind of demonstrating that you just forgot. So again, it's one of those things where if you credibly can demonstrate that you forgot and it's reasonable, you might be able to kind of demonstrate that.
So in a changing market, are you seeing more lawsuits and more questions about disclosures?
It's funny, when prices go up, no, because people figure, why am I doing that? Prices have kind of stalled a little bit. In some cases have gone down. So I'm seeing more and more disclosure issues. Again, people jokingly say, well, buyer just wants to get their kitchen remodel paid for. Yeah, that is true. So again, I'm seeing more of those because, again, a little bit, sometimes buyer's remorse kicks in a little bit. And by the way, that's going to change a little bit, I think, by virtue of this Amgen news. With regard to the new research and development facility, that actually may increase prices, which may, again, dissipate some of the disclosure issues. But then what I end up having more of then is easement and lot line issues that are still really, really important.
Good segue.
I thought I'd kind of segue. Most people, when you buy a property, people don't even know where their lot line is. Do me a favor, find out. So it's important to know where that lot line is, because I had the other day, there's somebody in my office actually who just found out their parents' house of 55 years was 2 feet over on the other property. And they didn't know it because the fence was put in that spot. So it's important to know before you buy where the actual lot line is. And I think we were talking before, I've seen a lot of people get not just a title policy, but there's actually a title survey where you go to your title company and actually get a survey of the property done, and they insure that. Cost more, but it's one of those things that if you have any questions about where the property line is, that's important. And a quick tip, I don't know if you've ever done this before, but if you go out to your property and you look at the curb, you may see a little bullet hole looking thing on the curb. That's actually where the lot line is.
Okay. Disclosures, easement. What else should a buyer and seller know to not hire a real estate attorney?
Well, the main thing is just to understand this is a complex process. And I have so many people that come to me wanting help understanding the documents, understanding the legal obligations. And again, I get that, but it's something that is in the documents. We were talking before, these documents have been expanded pages and pages and pages. So sometimes people don't want to read them. Just basically make sure that you're understanding what you're buying. It's your property at the end of the day.
Okay, so Megan's Law, neighbors nearby,
Neighbors.
senior centers, rehabilitation centers.
So huge issue there too is also go talk to the neighbors, because there's a lot of times people will say, well, I can get out of this deal because there's a 6-bed, which is a senior care facility with 6 beds or less, 3 houses down. No, you can't, because that's actually allowed by law without necessarily a permit or any zoning prohibition. So talk to the neighbors, walk around the neighborhood.
And that is not a disclosure issue.
Correct. It's not a disclosure issue because, again, it's allowed by California law. The state wants to promote a productive use of land, and having a senior care facility or a drug rehabilitation center or a cat rescue. Some of these things are actually good uses of property that we want. You may not want it as a new owner in the neighborhood, but it's something that the state does sanction and approve, so to speak.
So obviously good information, lots of information. If you want to not hire a real estate attorney, make sure and read the documents, do all your inspections, and most importantly, just take your time. It's an important purchase. And if you do get in trouble, Don Lanson is here for you. Thanks, everybody.